question. That's why I asked it. And I thought that every beginning lawyer should know it, no? But to my surprise, no, a lot of our examinees were unable to distinguish between a compulsory and a permissive counterclaim. Now, if you go to the next slide, you will see, no, these are the tests to determine whether a counterclaim is compulsory or permissive. Okay, now let's go to section 8, which is a cross claim. Okay, so we know that a cross claim is a claim by one party against a co-party, no? So kung co-defendants kayo, it's a claim by one defendant against his co-defendant, no? The only change there is that the addition of that phrase to cover all or part of the original claim. All right, let's go now to section 10 on reply. We've already discussed this, no, earlier, but this is the actual provision defining the reply, no? So all new matters alleged in the answer are deemed controverted, no? Well, that was our rule even before. If the plaintiff wishes to interpose any claims arising out of new matters so alleged, such claims shall be set forth in an amended or supplemental complaint. That is important. That is new. Okay? So ngayon, if there is a new matter alleged in the answer, you can choose not to file anything, okay? And then that will be deemed controverted. That's okay. That was our rule before. Okay. But now, if you want to allege new matters to controvert the new matters alleged in the answer, you cannot do it in a reply because we have prohibited the filing of reply except only if an actionable document was attached to the answer, right? So what can you do? You file an amended complaint, okay, or a supplemental complaint. That is now your remedy, okay? And then, however, plaintiff may file a reply only if the defendant attaches an actionable document to the answer, as I already mentioned, right? Okay. Okay, so the next paragraph is a definition of what a reply is. So we added there relating to the actionable document because we are limiting the reply now to the actionable document attached to the answer. All right, next slide, please. Now the last paragraph, okay. The last paragraph states that in the event of an actionable document attached to the reply, okay, the defendant may file a rejoinder if the same is based solely on the actionable document. Okay, so here you have a complaint, and then the defendant in his answer attaches an actionable document. Let's say it's a claim for a sum of money. The plaintiff alleged that the defendant owes him a sum of money based on a promissory note. Let's say the promissory note is attached to the complaint, right? Now the defendant files an answer. The defendant says, no, that is already paid, okay? The defendant attaches an official receipt or an acknowledgement receipt of payment, or maybe a check, no, that was encashed. Okay, so that's the actionable document of the defendant, okay? So the plaintiff now may file a reply to controvert only that actionable document, deny it under oath, or allege any other matter, no, to defend against that particular allegation that there was already payment. Okay. Now, in the reply, the plaintiff may attach another document. The plaintiff may attach, for example, a notice of dishonor that the check which was attached as an actionable document to the answer of the defendant was actually dishonored by the bank when it was presented for encashment, no? So that could be the actionable document attached to the reply. Now, in that instance, the defendant, okay, is given an opportunity to file a rejoinder. But please pay attention to the use of the word may. It's entirely discretionary on the part of the defendant to file the rejoinder. It's not mandatory, right? So, and then the defendant now will have an opportunity to disprove the allegation that the check bounced, okay, in his rejoinder, right? It's only fair, no? All right, so there at the bottom, I said we cross-reference this with section 2 on pleadings allowed. So just to reiterate, no reply will be allowed unless an actionable document is attached to the answer. And then all new matters alleged in the answer are deemed controverted. And then, as already mentioned, when can you file a rejoinder? It's there, okay? All right, let's go to the next slide, Attorney Renz. Okay, section 11 refers to the third, fourth, etc. party complaint, no? In my 11 years as a trial court judge, I've never had a chance to have anything beyond a third party complaint, thankfully. Okay, but it's provided for in the rules. It happens, I know, but not in my courts, no? So Now the change is in the second paragraph. This is new, no? The third, fourth, etc. party complaint shall be denied admission, and the court will require the defendant to institute a separate action where, okay? So first, we allow a third or fourth party complaint, but we will not allow it in the following instances. First, if the third party defendant cannot be located within 30 calendar days from grant of leave to file a third-party complaint. Okay? Kasi you have to ask the court for leave, no? Kasi you will note, this is a carryover. This was our rule already before. You can only file a third-party complaint with leave of court. Okay? So if the defendant in your third-party complaint cannot be located within 30 days from the court's order granting you leave to file that third-party complaint, then the court will dismiss, okay, or deny admission of the third-party complaint. Okay, so if the third-party complaint has already been admitted, summons had already been issued, and summons could not be served within 30 days, then the third-party complaint will be dismissed, all right? And then number two, the second exception, second instance, when the court will deny admission of the third-party complaint or dismiss it, is when matters extraneous to the issue in the principal case are raised, okay? So, for example, the A versus B, sum of money, and then B versus C for the same amount of money, but not related to the issue between A and B. That's a classic third-party complaint, okay? Let's say that B alleges, okay, B is the original defendant, B is now the third-party plaintiff, he alleges against C, the third-party defendant, that he gave the money to C, okay, for C to deliver it to A, and C never delivered it to A, okay? So that's the nature of third-party complaint, okay? Now, C can now, by way of defense, introduce a matter which is extraneous to that, okay? Like C can allege that, well, I used it to pay for your other obligation to another person. That's a matter which is extraneous to the issue between A and B and C, right? So that could be a ground for the court to deny the admission of that third-party complaint or to dismiss it and to prompt B and C to litigate it in a separate action. Okay, now the third exception would be when it introduces a new and separate controversy. The example I just gave could fall within that particular example also. Or if, for example, the third party plaintiff, who is the original defendant, says that he gave the money to C, but then C alleges that, well, B, original defendant and the third party plaintiff owes C for some other reason, like let's say a rental arrearage, no? So that is also a ground for not accepting or admitting the third party complaint, or for prompting the third party plaintiff to file a separate case which will not muddle the issues or cause the issues in the original complaint to drag on indefinitely, right? Okay, let's go to the next slide. Well, there I have for you the requisites for a third-party action, no? And well, it's from jurisprudence also. And at the bottom, I have a list of what we already discussed, no? The exclusions when a third-party complaint shall be denied admission. Okay, right. Okay, let's go to Rule 7. Okay, you will see there, can we go back, Attorney Renz, to the title page? There, the addition of and contents. Before, Rule 7 was just parts of a pleading, but now it's parts and contents of a pleading. Okay, so this is very important. You will see later on why, all right? Now, let's go to the next slide on signature and address. Okay, so you will see that what we did here was to already number the paragraphs, okay? Although these provisions were existent already in our old in the 1997 Rules on Civil Procedure. We just added some clarificatory phrases here, and of course some additional paragraphs. No, but we numbered them. We thought it best, no, for clarity also, and also for easier reference. We numbered them. Okay, you will see here now. No, we are requiring this. The signature of counsel constitutes a certificate, no? Not only that he has read the pleading, okay, and that it is to the best of his knowledge, information, and belief true, no? So, but now we also want this signature to attest to the following things. And you have that enumeration. Number one, that the pleading or the document is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Next slide. Second, claims, defenses, and other legal contentions are warranted by law or jurisprudence. They are non-frivolous, no? And they are extended for the purpose of probably modifying or reversing existing jurisprudence, no? Third, that the factual contentions have evidentiary support, or if the factual contentions are specifically identified, they will likely have evidentiary support through the availment of modes of discovery. Okay. Fourth, that the denials of factual contentions are also warranted on the evidence. And if so specifically identified, then they are reasonably based on belief or lack of information. Okay, let's go to the next slide. Now, the important part here for our practitioners is this paragraph no, on sanctions, because the Supreme Court thought that to enforce this particular provision, sanctions may be necessary, and this was the provision that the committee and the Supreme Court and bank approved. No, if the court determines on motion or motu proprio. So the court has power to do this on its own motion, and after notice and hearing. Okay, there you have the guarantee of due process and fairness. There must be notice and hearing. If the court determines that the rule has been violated, okay, it may impose an appropriate sanction, or it may refer the violation to the proper office for disciplinary action on any attorney, law firm, or party that violated the rule or is responsible for the violation. Okay, so then you have the responsibility or liability of a law firm there, which is made joint and several, with its partner, associate, or employee who committed the violation. And the sanctions may include, but will not be limited to, non-monetary directives or sanctions. There can also be a payment of penalty in court, or if warranted. And for deterrence, an order may be made to direct payment to the movant, no, or to the adverse party of all reasonable attorney's fees, no, as in the discretion of the court. Okay. And there is a last statement there that the lawyer or the law firm cannot pass on the monetary penalty to the client. No, well, the thinking was that it will be the lawyers will be more cautious with the addition of this last statement. Okay, so what is the basis for all of this? No, we, as officers of the court, all practitioners have an obligation. They all owe candor, fairness, and good faith to the court, no? And you must all assist in the administration of justice. Now, if we are going to aim for speedier, faster, and more just litigations, we have to be secure in our belief that everybody is exercising good faith. All right. So this particular section really rests on the good faith of everybody. And so when we see your signature on a pleading or a document that you submit to the court, this is what we will believe. This is what we will take to be the truth, no? Because you have attached your signature to this particular document. And so if the contrary is proven, no, and a violation is established, the court deemed it proper to impose a sanction, because it will be, in effect, a violation of the Code of Professional Responsibility. And I have here Canons 10 and 12 for you to look at. They refer to, as I said, an officer of the court's duty to the courts. Specifically, the lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice, and of course, not to misuse court processes, okay, and the rules of court, right? Okay, let's go to the next slide, Attorney Renz. Verification, okay? So we all know that not all pleadings are required to be verified, no? But there are certain pleadings that are required to be verified. And when they are required to be verified, how do you execute a verification? Now, this is the section that tells you how a verification is executed. So a pleading is verified by an affidavit, okay, by an affiant who is duly authorized to sign the verification, of course. the important revision here is the succeeding sentence, no? The authorization, whether it be in the form of a secretary certificate or a special power of attorney, must now be attached to the pleading. Okay, well, in practice, we really do that, but in practice also, we know that there are those among us who still do not attach it, no, to the initiatory pleading. So it prompts the judge to ask for it. Sometimes a judge will even direct you to show cause, no, why your initiatory pleading should not be dismissed because there is no authority or evidence, no, in the pleading. Okay, so to avoid all of that, we made it very, very particular already. You have to attach the authority of the verifier. Okay, it has to be attached to your initiatory pleading or to the pleading that needs to be verified. Okay, and these attestations will be part of the verification. No, first, that the allegations in the pleading are true and correct. But now, the basis of this statement or this verification of truth, no, and correctness is either personal knowledge or authentic records. Okay, wala nang iba na. Wala nang knowledge, information, and belief. It's now personal knowledge or based on authentic documents. Okay, let's go to the next slide. Letter B, that the pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Okay, we want this already in the verification. And then letter C, that the factual allegations have evidentiary support. All right. Now, the signature of the affiant shall further serve as a certification of truthfulness. All right. So this just makes it or harmonizes it with the preceding section, right, on the signature. Okay, now let's go to section 5, which is the certification against forum shopping. The only change here, you can go to the next slide, Attorney Renz. You can go to the next slide, Attorney Renz. There you go. Okay, the only change here is at the last part where we say that, again, like in the verification, we now want you to attach proof of the authority of the person who will sign the certification against forum shopping, no? So whether it's a sex cert or an SPA, we want it attached, no? Now, if it's not attached, then it will be a violation of an express provision of the rules of court, and you know what that may be, what that may result to, no? Okay, the other changes, insertion of the word calendar before the word days, no, for the counting or computation of the period. Okay, and let's cross-reference it also to the verification requirement regarding the authority, no? Let's go to the next slide. Okay, just as a review, no, I have here on the screen a definition of what forum shopping is, but I'll not discuss it with you. You read it at your own pace. No, but I just want to remind people that under section 5, no, there are two things that are asked of you. Okay, first, number one is to submit a certification against forum shopping, or what we call the certification of non-forum shopping. Okay, that's the first thing that's required of you. If there is absolute non-compliance, okay, then you're doomed. Okay, so your initiatory pleading gets dismissed outright. Okay, and it's incurable. Of course, we know of Supreme Court decisions which established exceptions, but that is very, very rare. Okay, if there's an absolute non-compliance, then it is, as a general rule, incurable. And of course, it is a dismissal without prejudice. You can refile it, okay? Number two, okay, you may have a certificate of non-forum shopping, which is defective, right? Let's say that there are two plaintiffs, okay? But only one plaintiff signed the certificate of non-forum shopping. That's a defective certificate in our jurisprudence, right? But it also falls within what we call the substantial compliance doctrine, no? So the choice there is with the court. The court can direct the party to submit a compliant certificate of non-forum shopping, or the court can just choose to go ahead, no? But the more prudent action for the court is for the court to direct the plaintiff or the party filing to submit a compliant certificate of non-forum shopping. All right. So that's a fact, the filing of the certificate. Now, the second act that Section 5 covers is the act of forum shopping itself. Okay, so, and we know what forum shopping is. Now, if this is what you violate, okay, for example, you state you have a certificate of non-forum shopping, but you actually have another case pending in another court involving the same parties and the same issues, all right? So that is forum shopping, okay? but you submitted a certificate and you did not declare that there is another case pending before another court involving same parties and same cause of action. No, so that is a violation of this rule against forum shopping. And what will be the result? Your case will be dismissed, okay, and you will be liable to criminal and administrative sanctions. Well, the lawyer at least will be liable to administrative sanctions, and you will also be liable for contempt. Even the party client will be liable for contempt, okay? Of course, in the rule, it says that all the related cases will be dismissed, no? But if I'm one judge and I'm the one who discovers the forum shopping, no, and I issue that order dismissing the case before me, I have no power to make the other court dismiss the related case. The most that I can do is to send a copy of my order to that other court, okay? And of course, I can also send a copy to the Committee on Bar Discipline of the IBP because the section provides for administrative sanctions, no? All right, okay, so that's just a review for all of us. Okay, let's go to the next slide. On the next slide, we see a side-by-side comparison of verification and forum shopping of the rules. No? So the purpose of verification is to attest to the veracity, no, of the allegations in the complaint or the initiatory pleading. Okay. On the other hand, what is the purpose of forum shopping? We don't want multiplicity of suits. We don't want conflicting decisions. And we don't want parties to trifle with the processes of the courts, right? Okay, now what is the effect of non-compliance with the verification? We know that it is generally curable. It does not go into jurisdiction. It is a procedural defect. Okay, although we say that an unverified pleading, no, when a verification is required, is equivalent to an unsigned pleading, meaning it's a scrap of paper, right? But it is really not jurisdictional. So the courts, for the most part, will allow you to remedy this particular defect. Okay, but forum shopping, I already explained to you the consequences in the event that you fail to submit a certificate, in the event that your certificate is defective, and third, if you commit actual forum shopping, right? Okay, let's go to the next, Attorney Ren, Section 6. Now we go to contents. This is an entirely new provision. Attorney Renz, let's go to the next slide. Okay, there you go. Thank you. So every pleading, no, I'm sorry. Can we go to the provision? Attorney Renz, the preceding slide. There. Every pleading stating a party's claims or defenses shall, in addition to those mandated by Section 2, Rule 7, meaning the body part, no, the designation of the pleading or document, then the allegations, then the relief, then the date. Now we're adding these things, okay? So these are mandatory allegations now, okay? The first one is the names of witnesses who will be presented to prove a party's claim or defense, okay? Second, summary of witnesses' intended testimonies, provided that the judicial affidavits of the said witnesses must be attached to the pleading and must form an integral part thereof, okay? So now we are requiring the judicial affidavits of witnesses to be attached to the pleading. Okay? So kailangan na po i-attach what is the consequence if you don't attach the judicial affidavits of your witnesses. The consequence is only witnesses whose judicial affidavits are attached to the pleading shall be presented during trial. Meaning, if you don't attach the judicial affidavit of your witness, then you cannot present that particular witness or intended witness during trial, no? Unless, okay, there is an exception, except if a party presents meritorious reasons for the admission of additional witnesses, no? Okay, it speaks of additional witnesses. It does not speak of the original intended witnesses, no? No other witness or affidavit shall be heard or admitted by the court. Okay, so if you attach one judicial affidavit, let's say you're the counsel for the plaintiff, you attach the judicial affidavit of the plaintiff, okay, you can only present the plaintiff. Now, it just so happened you were unable to prepare the judicial affidavit of another witness, a material witness who will testify to the claims of the plaintiff, because that witness, let's say, was unavailable for some reason. Let's say that witness is a non-resident of the country and only came home of late, okay? So now you can pray for the court on the basis of that meritorious reason to admit the judicial affidavit of your additional witness, okay? So that that witness can also be presented during trial, no? So you will note here that the court did not make a provision for your original intended witnesses whose judicial affidavits you failed to attach to your pleading, no? And because of that, you have to refer to the judicial affidavit rule, okay, which is our special rule on the matter. And what does the judicial affidavit rule say about this? No, the jar, we call it the jar. The jar allows the admission of late judicial affidavits, right? No, one late submission is allowed, but there is a payment of a fee, okay, which we were trying to question, because we said that if there is a meritorious reason, why impose a fee, okay? But that's just my opinion. Anyway, so you're allowed one late submission. So if this provision does not specifically bar that late submission provided for in the special rule, which is the jar, the judicial affidavit rule, then it is my humble opinion that you can do a late submission, but subject to the requirements of justifiable cause. Okay, and of course, what the jar requires, the payment of the one-time fee. All right. Okay, so but this is very clear. You now have to attach the judicial affidavits of your intended witnesses to your pleading. If you do not attach it, then your intended witness cannot testify during trial. Right. And then the third one, not only testimonial evidence, which a judicial affidavit is, as we discussed yesterday in our rules on evidence, no, but also, letter C, documentary and object evidence must also be stated already. Okay, so you have to state it. No, we're talking about the contents of the pleading, we're not talking about the documents that are being offered already or presented to the court. No, so you have to state already in your pleading that you are presenting the following documentary and object evidence in support of the allegations. But of course, these documentary and object evidence would already be included in your judicial affidavits, right? Because your witnesses will be the ones to identify or authenticate this evidence, and you would necessarily refer to them in your judicial affidavit. So kaya sama-sama na po talaga lahat yan, okay? All right, so this new provision on contents is what really establishes or institutionalizes the shift from ultimate facts to evidentiary facts. Okay, let's go to the next slide, Attorney Vance. Okay, so here, as I said, no, you just cross-references to Rule 8, Section 1. So ultimate facts pa rin yung ginamit natin, but now we add the phrase including evidence, all right? And then, okay, so what is the reason why we are doing this, why we are going to implement this change? No, because we want to lay the cards on the table as early as possible. We want to give everyone all the opportunity to prepare. Okay, and that is the reason why we don't want, I think I mentioned this yesterday also, we don't want trials conducted in the dark, okay, so to speak, all right? And so we want you at the very first instance to disclose what is your case and what are the evidence that you are going to introduce to support your case. Okay. Right, let's go to the next rule, Rule 8, manner of making allegations in pleadings. Okay, Section 1, no? So, as I already mentioned, here we still stick to ultimate facts, but now we added the phrase including the evidence, no? Right? And then in the second paragraph, if a defense lang before, no? So we added cause of action. If a cause of action or defense is based on law, then the pertinent provisions should also be clearly stated. Right, let's go to the next slide, Section 6 on judgment. We added the sentence at the last part, an authenticated copy of the judgment or decision shall be attached to the pleading. Just as a reminder of what we discussed yesterday on the effectivity of the Apostille Convention for the authentication of documents coming from a foreign jurisdiction, no? So you only need that apostille certificate from the DFA, no, to authenticate your foreign document or the foreign originating document. Okay, let's go to the next slide. Section 11, allegations not specifically denied are deemed admitted. Okay. All right, so we just added material averments, no? We made it plural. And then we changed complaint to pleading, no? So to a pleading which asserts a claim, any pleading which asserts a claim, no? So that's the only change there. And then let's go to the next one, Section 12, affirmative defenses. Okay, this is a new provision. We entirely rehauled this, no? And I've discussed this already, but we will repeat it because it's important. First, a defendant shall raise his or her affirmative defenses in his or her answer, okay? And it shall be limited to the reasons set forth under Section 5B, Rule 6. And what are these reasons? Well, fraud, statute of limitations, estoppel, release, payment, etc. No, those are the reasons, okay? And then after those grounds and the following grounds, ito yun, no? Court has no jurisdiction over the defendant, venue is improperly laid, plaintiff has no legal capacity to sue, the pleading asserting the claim states no cause of action, and a condition precedent has not been complied with, okay? And then letter B, failure to raise the affirmative defense at the earliest opportunity will constitute a waiver. What is the earliest opportunity for you to raise it? Of course, when you're filing your answer to the complaint, okay? Or when you're filing your reply to the answer, okay? Or when you're filing your reply to a counterclaim, okay? And then Section 12, next page, please, next slide. Okay, letter C, the court shall motu proprio resolve the above affirmative defenses within 30 calendar days. As I told you, there are two modes of resolution here. First, the court motu proprio will resolve it. That goes for those grounds which are evident from the face of the complaint, where the judge does not need to receive additional documents or evidence from the parties because everything that the judge needs is already in the pleadings before him or her. Okay, so that's a motu proprio resolution, 30 calendar days from filing of the answer. Now, there is another way, no? If the judge feels that the pleadings before him are insufficient, okay, and he needs more enlightenment on the facts that are asserted, no, then he can set it for a summary hearing, okay? And the party, it will be the court's duty to issue the notice of summary hearing, okay? So walang magpa-file ng motion to set affirmative defenses for hearing. That is a prohibited pleading. You will see later on, okay? So such affirmative defenses will also be resolved within 30 days. But this time, you count the 30 days from the termination of the summary hearing, okay? And then letter E, affirmative defenses, if denied, shall not be the subject of a motion for recon or a Rule 65 petition, okay? But must be later on raised on appeal after a judgment on the merits. So same rule natin yon, okay? So if your affirmative defense is denied, okay, that means the court must go to trial, okay? That the court must proceed pre-trial, trial, and then judgment on the merits. Only when you're appealing the judgment on the merits can you assign as an error the denial of your affirmative defenses. All right? Okay, let's go to Rule 9, effective failure to plead. Okay, so here you have the rule on default, no? No change here except in Section 3. Next page, please. Well, gender inclusive language again. And then next page, please, Attorney Renz. In the next slide, you will see, Attorney Renz, there, that we just added the phrase Solicitor General or his or her deputized public prosecutor, no, in place of the prosecuting attorney. That's just for clarity. Okay, so let's go to the next slide. Not much to say. It's the same rule, no? Still, the jurisprudence still applies. Okay, so I have here one for you. What are the effects of default? Oh no, these are the three instances when the effects of default are followed, no, or enforced, no. The first is the actual default. This is the default proper when an answering party fails to file his answer or responsive pleading within the period allowed by the rule, no. Second, if there is a failure to appear at the pretrial conference on the part of the defendant, no, but that is not called as in default anymore, no? Since the 1997 revision of the Rules on Civil Procedure, wala na tayong default as in default, no, for non-appearance at pretrial. But the effects are still the same. You no longer participate in trial, okay? But you are still entitled to notices, okay? Especially notice of the decision, all right? And then the third instance would be when one refuses to comply with the modes of discovery under the circumstance in Section 3C, Rule 29, okay? So there will be a judgment rendered by default against a disobedient party. Okay, so for example, you refuse to comply with an order for the production of documents or for examination, etc. All right? Okay, Let's go to Rule 10, amended and supplemental pleadings. Okay, in Section 3, amendments by leave of court, no? So the Supreme Court added these provisions, no? An amendment by leave of court will be refused, no? If the amendment before, the only ground that we have is delay, okay? If the amendment will result to delay, okay? But now we added these grounds, no? If the amendment is to confer jurisdiction on the court, okay, when from the original complaint or original pleading, it was evident that the court had no jurisdiction. So alam naman natin yun from jurisprudence. You cannot amend or you cannot grant an amendment which will confer jurisdiction on the court. Second, or third, the third being that the pleading stated no cause of action from the beginning. Okay, so you cannot also amend if the purpose is to plead a cause of action which was not there in the beginning or in the original pleading. All right, so next slide. So there you have it. For you, I have here the elements of a cause of action, no? For your for your easy reference. Then next slide. Since the next slide, please, Attorney Renz. Since the trend is liberality towards amendments, this has been the trend, no, since the 1997 revision of the rules, no. So, and the only condition before was that it not be for delay, no, that it will not delay the main case, or will not unduly prejudice the rights of the parties, no. Ngayon, we thought of medyo adding these restrictions, no. But these restrictions, as I already mentioned, are already found in jurisprudence, okay? And so I already mentioned them to you. No amendment to confer jurisdiction, and no amendment if the pleading failed to state a cause of action at the outset, okay? Let's go to the next one. All right. The next one is Section 5, no? Yung amendments necessary to conform to or authorize presentation of evidence. Before, Section 5 was so magulo, okay? Because it said that the amendment will be by motion, no? You can file a motion even after judgment, no, to amend to conform to the evidence presented, which was not objected to by the other party. But then the provision also says, even if you fail to file that motion, then it will have no effect on the judgment rendered on the basis of the evidence so presented, no? So parang self-negating, and that is why in the revision we just clarified it and made it simple. No amendment is necessary, okay? If issues which are not raised are tried with the consent of the parties, whether the consent be expressed or implied, then it will be treated in all respects as if it had been raised in the pleadings, and no amendment will be necessary, no, to cause the original pleadings to conform to the evidence. So wala nang kaguluhan, no? Simple na lang, ganyan na lang tayo. Okay? Next, let's go to the next slide. All right, the next slide, please. The next slide, Attorney Renz. So I have here a quote from PNB versus Pauses Manalo. Okay? So the reason why we made the rule this way is this, no? For so long as the basic requirements of fair play had been met, litigants were given the full opportunity to support their respective contentions and to object to or refute each other's evidence, then the court will validly treat the pleadings as if they had been amended to conform to evidence. Okay, so yun, just to make it simpler for everybody. Let's go to Section 8, the effect of amended pleadings. No? So the only change here, next slide, Attorney Ren, Section 8. Okay, the only change is to change the word received in the old provision to offered, no, which is better, no. So it's really stylistic. But at the bottom, I just wanted to remind everybody, no, when you amend a pleading, then the original pleading is superseded, no. The amended pleading takes the place of the original pleading. The original pleading will become inexistent. Okay, so it is no longer going to be considered. Okay, so why is that important to us? In Ching versus Court of Appeals at the bottom of your screen, the court pointed out that while it is, before it is amended, all the allegations there may be considered judicial admissions, right? But as soon as it is amended, the amended pleading takes its place, no? The original pleading now, the allegations therein no longer constitute judicial admissions. Diba? Kasi taken out of the field na siya of trial. Eh. Okay? So, nabura na siya. Nabura na lahat ng effects niya. But what can it be? Now, it just becomes an extrajudicial statement. Okay? And any admissions therein will be considered extrajudicial admissions. So, anong consequence nun? Pag judicial admissions, conclusive, right? No proof is necessary. That's why it's under judicial notice, okay? Pero pag extrajudicial admissions, it requires proof. So it has to be offered and it has to be admitted, okay? All right, next. Now we go to Rule 11, when to file the responsive pleadings, no? Okay, so some changes here. And the very first change is that now you're given 30 calendar days, no, to file your answer to a complaint. And why is that? Well, you all know that it is because now we have shifted to the evidentiary, no? And it's no longer just ultimate facts. We are requiring the defendant to attach all his evidence, no? Judicial affidavits, object, etc., to his answer, no? To his initiatory pleading. And so we are giving the defending party a longer period of time, which is 30 calendar days. Of course, it also says unless a different period is fixed by the court, right? And we also acknowledge that 30 days might not be enough. And that is why we have a provision coming up about an extension. Okay, let's go to the next slide. The answer of a defendant foreign private juridical entity, 60 days, well, for obvious reasons, okay? But remember, all the days are qualified now by the word calendar, okay? Just for clarity. Okay, Section 3. Let's go to Section 3, Attorney Renz. Okay, answer to amended complaint. Where the plaintiff files an amended complaint as a matter of right. Now, the first one is as a matter of right. Okay, so the answer will be within 30 calendar days after being served with the amended complaint. Okay, so kasi a matter of right pa yan. Okay, so the answer is the same period of 30 days, but after service of the amended. Okay. Now, when the filing is no longer a matter of right, meaning leave of court had to be secured, no? So it becomes 15 calendar days. Why is that? Kasi the defendant already had noticed, no, that there was a motion for the admission of an amended complaint, and the court will and the court issues an order. So that took some time, no? So that time, from the very first time that you learn that there is a motion to amend the complaint, dapat and you ano ka na, 'di ba? You are put on notice already, no, that there will be an amended complaint coming. So kaya meron ka ng leeway or period of time already when you can prepare your answer to the amended complaint. Kaya ginawa na lang 15 calendar days yan. All right. Let's go to the next slide. Answer to counterclaim or cross-claim. Section 4, 20 calendar days. And then Section 6 is the next one. It's the reply, no? A reply, if allowed, no? So we cross-reference it to Section 10, Rule 6, and we know that it's only allowed if an actionable document is attached to the answer, may be filed within 15 calendar days, okay, from service of the answer or other pleading responded to. Okay. Next, Section 7, answer to supplemental complaint, 20 calendar days also. It's no longer the original 30 days because this is just an answer to a supplemental complaint. So more or less, nakita mo na dun sa original complaint, and baka nga may answer ka na din sa original complaint, which you can adopt as your answer, even to the supplemental complaint, if you feel that the supplementary matters alleged are no longer necessary to be controverted. Okay, and then Section 11. Okay, Section 11 is the extension of time to file an answer, all right? This is a provision, this is a new provision, okay, in regard to the particular matter that only one motion for extension of time to file an answer is allowed, okay? So let's be clear here, okay? So general rule, no motion for extension. That's our new rule, huh? No motion for extension to file any pleading. Right? That's the general rule. Except you can file one motion for extension of time to file an answer. Okay? So one only. And what is the maximum period that a judge can give by way of extension to file an answer? Maximum period is 30 days. Okay? So you can only file one motion for extension of time to file an answer, and the maximum period is 30 days. So from the original 30 plus the extended period of 30, the maximum period to file an answer is 60 days. Okay? So again, no more motion for extension of time to file any pleading except one motion for extension of time to file an answer. And the maximum period that you can avail of is 30 days. All right? Okay, but here, let's go to the second paragraph, no? Merong qualification dito. A motion for extension of time to file any pleading other than an answer is prohibited, okay, as I told you, and considered a mere scrap of paper. But look at the second line. The court, however, may allow any other pleading to be filed after the time fixed by the rules, okay? So, again, let's repeat that, no? The court, however, may allow any other pleading to be filed after the time fixed by the rules. What is the implication? Okay, it would seem that the court is being given discretion to admit belated pleadings, okay? Except the answer. Okay, and why is that? Kasi binigyan natin ng motion for extension yung answer. But all the other pleadings, binawal natin yung extension of time. Okay? So you see, it's fair, no? So bawal ang motion for extension of any other pleading. Okay? Ang pwede lang mag-motion for extension to file an answer. And the maximum is 30 days. But the last sentence seems to give you, the court trial judge, the discretion to admit belated pleadings, but not a late answer. Okay? All right. But syempre, yung exercise ng discretion natin must not be with grave abuse, okay? And it must not exceed our jurisdiction also. Otherwise, we will be liable under Rule 65, okay? Now let's go to Rule 13 on the filing and service of pleadings, judgments, and other papers, okay? Now, the revision in Section 1 on the coverage is just to add motions and other court submissions, no? Kasi before, it only referred to other papers, no? Ano yung other papers na yun, no? So, we wanted to be very clear and technical about it, okay? So, hindi lang pleadings and motions, but court submissions, okay? Court submissions. Let's limit it to court submissions because we're talking about civil litigation, all right? Okay, so Section 2, filing and service. Okay, so what is the difference between filing and service, no? Well, the distinction has long been drawn. It's understood to all of us, and it's there in the definitions also. Well, filing is the act of submitting something to the court, submitting a pleading or other court submission, no? Any document that you file in any civil case, okay, officially, okay? So that one that will become part of the record of that civil case, that is a submission. So that is filing, if you are filing it or submitting it to the court. What is service now? Service is serving a copy or giving or providing a copy of that court submission to the adversary or to your co-parties, no? Or counsel, as the case may be. Okay, so yun yung service. Okay, so the changes in this provision are just for clarity. Okay, so grammatical and stylistic, meron ding gender-inclusive language dyan. But the real change is on the next slide, Attorney Renz. Let's see. We added one paragraph where several counsels appear for one party. Okay, so minsan ang isang party is represented by more than one counsel. Okay, so where several counsels appear for one party, then that party will be entitled to only one copy of the pleading or paper to be served. Okay, kanino natin ibibigay? Kasi several sila. We give it to the lead counsel if one is designated. If no lead counsel is designated, service on any of the counsels officially appearing or formally appearing for that party will be enough. Okay? And then next, if there is one party, if there is one counsel representing several parties, no? Sometimes two plaintiffs, both represented by one counsel, no? So that counsel is also entitled only to one copy of the pleading or the submission, okay? But it will already be deemed service for all the parties that counsel is representing, okay? All right. go to the next slide, Attorney Renz. No, so it's just a, well, again, a quote for you to look at your own time regarding the service once a party is represented by counsel. We know that once a party is represented by counsel, only service to the counsel will be deemed valid service. Okay, let's go to section 3. What the manner of filing? Okay, so importante to, no, especially with what has happened to us because of the pandemic, no. Itong mga changes dito very timely, no. Okay, so how do you file pleadings and other court submissions? Well, we still have the traditional, no, the personal. And how do you file personally? Well, you go to court, and then in court, the date and the hour of filing will be stamped on the face of your court submission, right? Okay, so that is personal filing. Okay, the second one is registered mail. You can send it by registered mail, and if you send it by registered mail, it will be the date of mailing. Okay, that will be deemed the date of filing. Okay, so the third mode is through an accredited courier. Okay, this is new. Okay, before, and jurisprudence is consistent in this, no? If you send something to the court or even to your adversary, and you send it through a private courier, no? It will be the actual date of receipt by the court or by your adversary, which will be deemed the date of filing or the date of service, no? Kasi before, these were just private couriers. Hindi sila accredited ng court. So wala yung presumption of regularity na hinahanap natin, okay? Which attaches to registered mails, okay? Which is done by our Postmaster General, no? By the post office. Okay, so now, paano yon? Sino ang accredited couriers? Now, this is something that the Supreme Court, through the Office of the Court Administrator, will do, or I don't know if they're already doing it. They will go through a process of accreditation of private couriers so they can be considered accredited couriers within the meaning of our rules. Okay. So now, if you send it through an accredited courier, the date of filing will be the date of mailing also. It will be like registered mail, but of course faster. And that is the reason why we want the couriers to be brought in. Kaya po namin ipinaglaban talaga ito, itong private couriers na to na ma-accredit, because we thought that we really need to move away from registered mail, which we otherwise call or aptly call snail mail, okay? And then the fourth one is electronic mail, okay? Ito, very timely, okay? Transmitting them by electronic mail or other electronic means as may be authorized by the court in places where the court is electronically equipped, okay? So, yan po, pwede na rin ang electronic mail or authorized other authorized electronic means like the one being used by the courts now. Meron na po tayong official court email addresses, no? In the appropriate issuances of the Supreme Court, recent issuances. And also we have yung kanilang Microsoft platform, no, for video conferencing and hearings. Okay. All right. So this is for filing. We're talking about filing. So email, pwede through the official email addresses of the courts. And then other authorized means, so far, wala pa. Yan lang, yung electronic email. Okay. And then next slide. Okay. So, eto lang, it's just a summary. I did the summary already for you. Okay, let's go to the next slide, Attorney Renz. Attorney Renz, let's go to the next slide, please. So, accredited couriers, as I already mentioned to you, the Office of the Court Administrator will take care of we're still on Section 3, Attorney Renz. Can you please go back? Section 3, manner of filing. There you go. So the process is for the court administrator to devise, no? Like for yung surety bond companies natin in criminal cases. And then electronic mail or other electronic means, as I already mentioned. And then we just have one quote there regarding private couriers, no? The existing jurisprudence, which will change now with the revision in our rule. Okay, let's go to the next slide on modes of service. Okay, now we go to the modes of service or the manner of service of court papers, no, on the other party. Section 5, Attorney Renz. Okay, so there you have it, no? Pleadings, motions, notices, orders, judgments, and other court submissions shall be served, okay, in this manner. Okay, first, personal pa rin. Second, registered mail. Third, accredited courier, pwede na rin. Fourth, electronic mail, pwede na rin. Fifth, we add one more, facsimile transmission. Okay? So, hindi po kami pumayag na pwedeng i-fax sa court. Okay? Hindi namin sinama sa filing yung facsimile. Okay? Pero sa service, pumayag kami. Okay? So, yung facsimile transmission, kasama po dyan sa service. And then number 6 is other electronic means. No? But later on, under Section 9, you will note, no, service by electronic mail or by facsimile or other electronic means is by consent of the parties. So, dapat may consent ang party dito. Well, we have to take into consideration that not everybody is technologically equipped or technologically adept. So kaya po binigyan namin sila ng consideration. We are going to consider their just pleas for exemption from these types of service if they are not equipped for it. Okay, so if they do not consent, we cannot impose it on them. All right, let's go to the next slide, Attorney Renz. So what is personal service? So, well, it's essentially the same thing. We just rephrase this, no? So personal delivery to the party's counsel or to the party if the party does not have a counsel, or to the authorized representative, no? So nilagyan po namin ng addition na authorized representative named in the appropriate pleading or motion. Okay? So kung halimbawa na-designate na natin who is our attorney in fact, no, for that particular litigation, then personal service can be made on that person. All right? Okay, let's go to the next slide. Section 9. Service by electronic means and facsimile. Section 9, okay, so now dito na institutionalize yung service by electronic means and facsimile. Okay, but here, the requirement of consent, okay, is shown, no? So, shall be made if the party concerned consents to such modes of service. So, kailangan po may consent, no? So, service by electronic means shall be made by sending an email to the parties or the counsel's electronic mail address or through other electronic means of transmission as the parties may agree, no? Or upon the direction of the court. And then, service by facsimile, of course, by sending a facsimile copy to the parties or the counsel's facsimile number. All right? Okay, let's go to the next slide, which is presumptive service. No? Ito, importante rin to. This is a new provision. One of the greatest causes of delay is that our notices don't get to the intended addressees on time. No? Kasi how do we serve our notices? Well, snail mail. No? Kaya nga, when I was still in the trial courts, I'd have my process server use his motorcycle, no, to serve our notice of hearings, no, our notices of hearing. Kasi kung at saka mga sampina namin, kasi kung hindi niya gagawin yon at aasa kami dun sa aming ni-registered mail, eh, makakancel lahat ng hearings namin, no. So out of our own pocket na lang, and my brothers and sisters in the judiciary know this and are doing this also. Alam ko yan. Pero ngayon, mas meron na tayong tulong, no? We can cut the delay with the electronic service, no, of our notices. But now also with this provision, we have presumptive service of court settings. Okay. So when will there be presumptive service of the notices of court settings, no? If the notice is mailed within 20 days for addressees within the same judicial region. For example, in the NCR, no? Na-serve yung notice of hearing sa'yo within 20 days preceding the date of the actual hearing, then may presumptive receipt ka ng notice, okay? And then if you're outside the judicial region where the court is sitting, so for example, I'm a QC court and you're from, let's say you're from Laguna, okay, you're outside my judicial region, then 30 day period, no? So it has to be 30 days from the date of the intended hearing, okay? And then if the numbers are satisfied, the 20 or the 30 calendar days, then you will be deemed to have received the notice of hearing. And your failure to appear, of course, should warrant the necessary. Well, show cause order muna siguro tayo. Wag muna tayo mag-sanction kasi presumptive receipt pa lang to, di ba? So the better and the prudent recourse here for the judge is to issue a show cause order directing the non-appearing party to explain the non-appearance despite presumptive receipt of the notice, no? and then of course to set the incident one final time. No, all right. By the way, we were doing automatic or no, I'm sorry, automated hearings, no? So yung automated hearings natin, yan po yung on the date of hearing, right there and then when your case is being heard, pagkatapos nung hearing nyo, the court is printing the order already, no? For that particular hearing. So if there is a setting there, you are in open court, you're already notified, no? Actually, even if it's not automated, no? Kahit yung ating mano-mano, kung you are notified in open court, I will not be sending you any more notices, no? That's what I did when I was still in the trial course, and I'm sure the others are doing that also, because there's no reason for you to be notified anymore because you were notified in open court, okay? Okay, let's go to section 11, which is the change of electronic mail address or facsimile. In the same manner as counsel and parties are required to notify the court of any changes in their addresses, no? They are also duty bound now if they consent to service by electronic mail or facsimile to inform the court of any change in their electronic mail address or facsimile number. And the same effect will result if they do not inform the court of any changes. It will be still deemed valid service if service is made to the official electronic mail address or facsimile number in the court records, okay? Let's go to section 12. Okay, section 12 is just the format and the contents. If you are filing or serving something via electronic mail, no, or serving via facsimile, then ito yung dapat laman. Section 12, Attorney Renz, section 12. This is the format and the contents. This one was entirely the creation of Judge Nilo Emboscado, no, our tech expert. So iyan po dapat ang makita namin pagka ang submission nyo is via electronic mail or via facsimile, no, yung service, ito po ang mga bagay na dapat indicated therein. Alright? Okay, let's go to section 13. Service of judgments, final orders, or resolutions. We added something here. Upon ex parte motion, can we go to section 13, Attorney Renz, please? Upon ex parte motion of any party in the case, a copy of the judgment, final order, or resolution may be delivered by accredited courier at the expense of such party. Attorney Renz, section 13. Okay. So why did we add this? No? Alam natin that, you know, all our judgments mostly we send through registered mail kasi hindi naman tayo gagastos dyan para i-personal service natin yan, no? But we also know that there are parties who want the decisions to be served on the adversary immediately also, and they are willing to undertake the expenses, no, for the deposit to the STF, no? So that's part of the deposit to the STF. Pwede rin po yun, no? So but dito, sabi namin, huwag nyo na kaming abalahin. Ang daming ginagawa ng process server namin, no? Ito, you can do it. Use an accredited courier. So that's one other utility of having the accredited courier. Hindi na po tayo matagal maghihintay ng mga return. Natanggap ba yung decision ko? Kailan magiging final ito? Kailan ako pwedeng mag-issue ng certificate of finality? Magbibilang pa ako, no? Nagbibilang pa tayo kasi iba-iba yung araw nung pagtanggap nila, no? But here, through a private courier or an accredited courier, mas magiging mabilis po itong prosesong ito. Section 14, conventional service or filing of orders, pleadings, and other documents. Section 14. Okay, so notwithstanding yung ating mga ating mga revisions, no, allowing electronic filing or electronic service or service through facsimile or other electronic means, meron pa rin tayong we still have this papers, court-issued papers or court-bound papers that we must insist be served in the traditional way. What is the traditional way? That is personal service or registered mail only. Bakit? Ano ba itong mga ito? Here is the list. No? Initiatory pleadings and initial responsive pleadings such as an answer. So itong mga ganito, you can only personally serve it and file it or serve it by registered mail. Okay. Second, subpoena, protection orders, and writs, okay, for very obvious reasons, okay? So, only by personal service or registered mail. Itong mga nasa letter B, mga court issuances yan, no? Mga writs and processes natin yan. So, kailangan ang service niyan imbued with the presumption of regularity. Kaya hindi natin siya pwedeng i-entrust dun sa courier, kahit na sabihin natin accredited yung courier na yon, okay? At hindi rin natin siya pwedeng gawin electronically, alright? Kasi may mga effect yan sa rights, private rights ng mga parties involved, okay? And then letter C, appendices and exhibits to motions or other documents that are not readily amenable to electronic scanning, okay? So ito naman, the party is given the option, no? Kasi ang iniisip natin dito yung convenience ng parties, alright? And then the last one, of course, are sealed and confidential documents or records. So pag ganun, hindi natin siya i-insist na ma-serve siya by electronic means. Alright? Okay. Let's go to section 15, completeness of service. Okay. So again, the introduction of service by accredited courier and electronic service. We will go to my explanatory slide, Attorney Renz, on completeness of service. Can we go to it, please? Next slide. Attorney Renz, the next slide, please. My explanatory slide gives you a list or a rundown of when service is deemed completed there. So personal service, it is complete upon actual delivery or receipt. Okay? Kasi the word used is delivery, but actually it's complete upon receipt. Okay? Diba? So complete upon receipt, and then ordinary mail, 10 days after mailing. Okay? But very, very rarely, I think I've not encountered an instance when ordinary mail was resorted to. No? Lagi tayong registered mail. So registered mail, we know this, upon actual receipt or upon presumptive receipt. And when is there presumptive receipt of mail matters sent by registered mail? After 5 days from the first notice of the post office. Kasi pagka registered mail yan, makakatanggap ka ng una, diba? May nakalagay yan sa envelope. First notice and then second notice. Alright? So 5 days from first notice. And then accredited courier upon actual receipt, or, okay, kung walang actual receipt, after 2 attempts to deliver by the courier. Okay, so 2 attempts, ha? Or after 5 days from the first attempt to deliver. Okay, so yan ang ano. So presumptive receipt yon, ha? So the una is actual receipt. And then after 2 attempts to deliver or 5 days from the first attempt, those 2 are presumptive receipts, okay? And then electronic mail at the time of the electronic transmission, or if available, at the time the electronic notice of service is sent, okay? And then facsimile transmission is upon actual receipt as shown in the facsimile transmission printout. We all know what that is, that slip of paper, diba, that comes out of your fax machine, right? Okay, so yan ang rundown natin ng completeness of service. Okay, now let's go to proof of filing. Let's go directly, Attorney Renz, to my explanatory slide on proof of filing. Okay, proof of filing. Let's go to my explanatory slide on proof of filing, Attorney Renz. Okay, there you go. First, if filed personally, but the document is not found in the record. Okay, how do you prove that it was filed? No, this has happened to me a couple of times, no, when I was in the trial courts. For example, at a hearing, no, and I will remind the party, counsel, you still have to file your comment on the motion of the other party. Then counsel will tell me, Your Honor, we have already filed our comment or our opposition. And then I will look at my record. It does not contain that comment or opposition. So that is something that was personally filed, but it's not in the record. So how do you prove it? Counsel brings out his copy, which contains or which evidences on the first page the stamp receipt or the stamp that the court has received it on a certain date and time. No? So that's the proof of filing personally. No? Next filed, if it's filed by registered mail, then you know that what you require is the registry receipt and the affidavit of the person mailing. Okay. Of course, if you have the registered, what do you call it? The registry return card. Okay, or what we call in short as the return card. Okay. If you have that, then very good, because if you have that, that's all you need to prove that the filing by registered mail. No. Pero kung wala nun, kasi matagal bumalik yun, no, the registry receipt plus the affidavit of the person mailing. Okay. And of course, what's stated in the affidavit, the date and place of the deposit, and that a deposit was made in a sealed envelope, etc., etc. Okay. Number 3, if it's filed through an accredited courier, what do you need? You need the affidavit of service of the person who brought it to the courier. Okay? Hindi mo kailangan ng affidavit to courier. Okay, what you need is an affidavit of the person who brought your paper to the courier's office. Okay? Plus the courier's official receipt and the document tracking number. Okay? So yun ang kailangan mo. And then if it's filed by electronic mail, you need an affidavit of electronic filing. From whom? From the filing party. Kung ikaw yung nag-electronic filing, you have to be the affiant, no? Plus the printed or paper copy of the submission. So yung affidavit plus the printed or paper copy of the submission. Or if you have a written or stamped acknowledgement of the filing from the clerk of court, well, that's proof of the filing. Okay? And then the last one, if it's filed through any other authorized electronic means, also an affidavit of electronic filing, plus a copy of the electronic acknowledgement of filing from the concerned court. All right. Okay, now let's go to proof of service. Let's go to the explanatory slide, Attorney Renz, on proof of service. Yes. My explanatory slide, please, Attorney Renz, on proof of service. Okay, so in the explanatory slide there, please pardon me. It says section 16 there in my slide. It should be section 17, okay? So section 17 on proof of service, okay, personal service. What is proof of personal service? Well, it is the written admission of the party served, okay? And what is that written admission? Well, yung signature of receipt, okay? Plus the date and time, di ba? Usually we have a portion where we stamp it, received by, etc., etc. Yun. That's the proof of personal service. Or if it's a court filing, then you have the official return of the court served, no? It can be the stamp receipt also of what you had filed, no? Or it can be the official return of the court server, okay? If it's a court issued paper, like for example, the summons, no? Or the service of a writ, then you have a server's return, no, to evidence the service of that writ or of the or other court process. Okay, or you have the affidavit of service of the party serving, no, stating the date, place, and manner of service. So that's proof of your personal service, no. Second, what's proof of ordinary mail? You have the affidavit of the person mailing, no, stating the date, time, and place of deposit. And then registered mail, the affidavit of the person mailing plus the registry receipt or the registry card alone, or the unclaimed mail itself, no, with a certified or a sworn copy or notice from the postmaster, no, that it was unserved. Ito yung tinatawag nating postmaster certificate, di ba? We often direct the postmaster to issue a certification of non-service or of service as the case may be, no? So that will take that place. And then we have the accredited courier, affidavit of service by the person who brought the pleading to the courier, and the official receipt and document tracking number, and electronic mail. Proof of service is the affidavit of the person who sent it and the printed copy of the transmittal. All right. Okay, let's go to the next slide, section 18, court issued orders and other documents. So these are court outgoing papers from the court. No, the court may electronically serve orders and other documents to the parties in the case, and it will have the same effect and validity as personal service or service by registered mail. Now, a paper copy of the order or other document electronically served shall be retained and attached to the record of the case. Now, specifically, now this is applicable with the rules issued by the court under the pertinent administrative circulars for the to be applied during the enhanced community quarantine, and now the modified community quarantine, and soon when we transition to the general. Is that general, the GCQ general community quarantine? Okay. All right. Let's go now to Rule 14 summons. Okay. Okay. So Section 1, this is significant because here, if you look at the old provision, there is no period of time, no, stated or fixed when the clerk is supposed to issue summons, and this became a great cause of delay for our civil litigations, no? Kasi lawyers will go to us and say, what happened to my complaint? We filed it 3 months ago. We filed it 4 months ago. We filed it 5 months ago. What's happening? Diba? So, sabi namin, para wala ng excuse, let's put a period here, no? So, we said here in the revised provision, unless the complaint is on its face dismissible under Section 1, Rule 9, no? Yung grounds natin doon, lack of subject matter jurisdiction, litispendentia, res judicata, and prescription, no? So, within 5 calendar days from receipt of the initiatory pleading and proof of payment, of course, of the requisite legal fees, the clerk of court must issue the corresponding summons. Okay, so binigyan lang natin siya ng 5 days. But please, no, to my brothers and sisters on the bench, let us be reminded, no, that it is an exclusive judicial function, no, to determine the sufficiency of a complaint or initiatory pleading. Okay, so whether a complaint is sufficient in form and substance, only the judge can do that, can make that determination. Okay, whether to dismiss a complaint outright for the grounds I stated or for any other grounds, like for example, forum shopping, etc. No, only a judge can make that determination. Okay, and I urge you to do that determination earlier now, because now we have a 5-day period for the clerk to issue the summons. Okay, so that is this will, this is a good start or a good kick-off for any civil litigation. Nasa umpisa pa lang, we are operating under strict timelines, because that is precisely what the Chief Justice wanted. No, gusto niya every aspect, every step of the civil litigation meron ng time frames. Kasi that is the only way you gauge the efficiency of the judge, no? Hindi yung meron siyang decision handed out in the within the 90-day period. Hindi lang yun eh. Kasi yung trial, it took 5 years naman, di ba? So na-decide nga natin within 90 days, pero yung trial natin, it took us 5 years, no? So parang nade-defeat yung objective ng civil procedure, no? Speedy, less expensive, di ba? Determination of the rights of the parties. So, yun yung gusto niya ngayon. Gusto niya matrack every aspect, every step of the litigation. Okay? So, ito, from the very get-go, no? Meron na tayong period, 5 days. Okay? All right. Okay, let's go to the next slide. So, what you see on the next slide are just, it's just a quote, no? Again, regarding the service of notices and summons in civil cases, right? Let's go to Section 2, Contents. Okay, this is important, no? So, yung summons, ito yung contents ng summons. Pero dun sa letter B, makikita nyo, we are now authorizing the court, our courts, to allow upon motion, and the motion is ex parte. Kasi sa complaint pa lang to, nasa summons pa lang tayo eh. So, yung plaintiff pa lang ang nandun sa case, no? Siya pa lang ang nasa jurisdiction natin. So, the plaintiff may make an ex parte motion to be authorized to serve summons on the defendant. Okay? Kung merong ganyang ex parte motion at na-grant yan, kailangan in your summons, i-indicate mo yan. Okay? That the court has authorized the plaintiff to serve summons on the defendant. Okay? Bakit natin to inaalaw, no? Well, the Chief Justice was the one who was really an advocate of this, no? Kasi sabi niya, ito talaga help in the small claims cases, no, in the service of summons in small claims cases. Kasi we know how difficult it is sometimes to find the defendants, no, and it causes great delay to civil litigations. Kaya ito daw malaking tulong sa ating small claims cases. So he really advocated the inclusion of this provision. Pero meron tayong safeguard dyan, which you will see in Section 3. Okay, let's go to the next slide. Okay, you will see in Section 3 who can serve, okay? So, of course, we have our sheriff, his deputy, etc., no, the process server. And then, in case of failure of service of summons by them, meaning the sheriff or the process server, the court may authorize the plaintiff to serve the summons, but we insisted on the inclusion of this phrase, no? Kami nila Judge Jolo and Judge Nilo, we insisted on the inclusion of this phrase, together with the sheriff. No? Kasi sabi namin, we cannot entrust it to a party. Diba? Kasi, of course, we have to presume the good faith of everybody. Pero wag na natin silang bigyan ng temptation. No? So, gusto natin from the very start, lahat in accordance with the rules on fair play, no? So wag natin sila bigyan ng masyadong leeway dito sa service ng summons kasi importante ito. This is the way we acquire jurisdiction over the other party, no? So kaya sabi namin, in-insist namin dapat may kasama pa ring court personnel, no? Kasi para yung presumption of regularity will still be there and the return can still be made by the sheriff or the other authorized court personnel who assists in the service of summons. Okay? All right. Okay, so can we go to the explanatory slide, Attorney Renz, under section 3? There you go. So first, this is the process, okay? The sheriff or the process server must first try to serve the summons, okay? Dapat merong attempt. Second, if the court officer fails to serve summons, no? So nag-return siya ng summons unserved, the court may now authorize the plaintiff or his representative, but they will serve together with the sheriff, meaning the sheriff must accompany, okay? Third, if the service is to be outside the judicial region of the court, okay, which is hearing the case, the plaintiff or the representative may be authorized to serve. Eto ha, pag outside your judicial region, wala nang qualification. No, it seems that there is no qualification anymore for the sheriff, to accompany the plaintiff or the representative of the plaintiff is in the service of summons. Kasi you will find this in a different paragraph and there's no qualification, okay? So ito kasi yung nangyari dun sa mga small claims, no? So mostly outside of the judicial region, tapos ganyan ang nangyari. Kaya very high ang success rate nila. All right, and then fourth, if the summons is unserved on any or all of the defendants, okay, the court will order the plaintiff to serve summons by other means available under the rules of court, no? Ano yung other means available na yan, no? Ako, lagi ko itong ginagamit dati when I was in the trial courts, no? We have, under the 1997 revision of the rules on civil procedure, we had Rule 14, Section 14. Ano yun? Ngayon, Section 16 na siya, pero Rule 14 pa rin. Yun yung service on a defendant whose whereabouts are unknown, no? So, ang nakalagay doon, regardless of the nature of the case, if the whereabouts of the defendant are unknown, no, you can serve by publication. Okay? So this is different from yung quasi in rem, no? So ito, as long as the whereabouts of the defendant are known, you may serve by publication. So that is the other means available under the rules of court. Okay? So dapat ang plaintiff, duty niya to prosecute his claim, di ba? So kung hindi siya mag-resort to this, di ba, that should be deemed a failure to prosecute, no? And especially if it has gone on for an unreasonable length of time. So it may result to dismissal. But of course, it will be dismissal without prejudice, okay? And then you also have a sanction for a false claim of service, no? So if you claim that service was made, ito yung sa plaintiff to who was authorized to serve, if you make a false claim of service and then proceedings are taken by the court, no? For example, it results in a default judgment, no? Then you will be penalized by a dismissal of your case, and the dismissal will be with prejudice, and all the proceedings will be nullified. Okay? There may also be sanctions against the plaintiff and or the counsel. All right. Let's go to section 4, the validity of summons and issuance of alias summons. Okay. Okay, we thought of including this kasi ang nangyayari, every time the sheriff or process server returns the summons unserved, nag-i-issue ang courts natin ng bagong summons, okay? Which is not right, okay? Mag-i-issue lang tayo ng alias summons pag nawala yung ating summons or pagka nasira siya, well, na-tear siya or whatever, tapos wala nang ibang kopya sa record natin, no? So those are the only times that we will issue alias summons. Okay, kaya clarify lang po namin dito. Kaya the second paragraph says, if there is failure of service after unsuccessful attempts to personally serve the summons, ano na ang next step ng sheriff? Next step is substituted service. Ayan na. So we will go to that, okay? Okay, let's go to section 5, service in person. Okay, we know how to serve in person. You give it, no? You hand it over. You hand a copy of the complaint and the summons to the defendant. But dito dinagdag to and inform the defendant that he or she is being served. Okay? So, hindi naman lahat ng tao alam kung ano yung implication nung na-serve sila ng summons, no? Although it is there in the summons, but not everyone also will read it, and not everyone who reads it will understand it, no? So, ngayon, dinadagdagan natin ng duty yung process server natin. Sabihin din sa defendant, na ito, sineserve kita ng summons, pinapatawag ka ng court, no? Something like that. Something as simple as that. Just to give the receiving party an idea that this is something important that should be given attention, okay? And then, andito rin yung concept ng tender, okay? So, although nandun na rin yan sa ating old provision, ang nakalagay lang doon, if he refuses to receive and sign for it, then by tendering it to him. Anong ibig sabihin ng tender? No? Maraming naguguluhan. Ano yung tender? No? So, to tender means to leave a copy of the complaint and the summons. Saan? No? Yung iba, pwede bang ilagay ko sa ilalim ng pintuan? Pwede ko bang ilagay sa mailbox? No? It has to be within the view and in the presence of the defendant. Okay? So kung halimbawa nilagay mo sa mailbox, sa gate, hindi mo nakita yung anino ng defendant, hindi pwede yun, no? So now in the present definition of tender, you have to leave it in the presence of or within the view of the defendant, okay? Let's go to the next slide. So these are just quotes from jurisprudence regarding service of summons and tender. Now, by the way, the definition of tender of service is taken from the Sheriff's Handbook. Okay, let's go to substituted service. Nako, etong sa substituted service, dito tayo lagi nagkakagulo. Ito, great cause of delay ito, no? Section 6 tayo, Attorney Renz. Kasi ito yung laging lack of jurisdiction over the person of defendant. Ito yung pupunta, may special appearance to question the jurisdiction of the court over the defendant. It causes great delay, okay? And a lot of motions and opposition, etc., etc. Tas may resolution, of course, ang court, no? So, para maano na natin yan, so that we can cut out all of those things, no? Ito na, in-institutionalize na natin yung process dito, okay? So, when do you resort to substituted service, no? You resort to substituted service if you have attempted personal service at least 3 times on 2 different dates. Ayan na. Alam natin lahat to, ito yung requirements. They have been in jurisprudence for a long time, no? And the classic case would be Manotoc versus Court of Appeals. Nandun yung step by step, no? So ito, nandito na, nilagay na natin sa provision for everyone's guidance, no? And then, who do you serve in place of the defendant kung hindi mo siya mahanap, no? A, at the residence, you leave a copy of the summons, no, to a person at least 18 years of age. Nilagay na po natin yung edad. Dati ang nakalagay lang, a person of suitable age. Although in jurisprudence, sinasabi na yan 18 years. So nilagay na natin dyan para wala ng kagulo, no, and confusion. And of sufficient discretion and residing therein. Dapat nakatira doon. Hindi pwedeng 18 nga siya, nandoon siya, pero hindi naman pala siya nakatira doon, no? So ano yung guarantee natin na makikita niya yung defendant at ibibigay niya yung summons, di ba? And then letter B, by leaving copies of the summons, no, and of the complaint dun sa office or regular place of business of the defendant, no? And kanino mo pwedeng iwanan doon? This is the addition, a competent person in charge of the place, right? But ito ang definition natin ngayon, it will now include but will not be limited to one who customarily receives correspondence for the defendant, no? So kung dun sa opisina mo, you have a receptionist na talagang siyang taga-receive ng lahat ng mga incoming mo. Well, that will be a person who is deemed competent to receive summons by way of substituted service. All right? Next slide. And then the third is by leaving copies of the summons. Ito na, no? Ito ang laging naging problema natin. Nakatira siya sa gated subdivision. Ang process server natin ayaw papasukin ng guard hanggang gate lang sila. Okay? Or nakatira siya sa condo, ayaw paakyatin ng guard. Hanggang doon lang siya sa lobby. Okay? So, iyan na yung mga naging common problems natin. And it became a way for evading service of summons. Kaya rin tayo nagtatagal, no? So, to eliminate this, we thought of including this provision by leaving copies of the summons if refused entry, ha? Only if refused entry. So, dapat may allegation sa server's return that you were refused entry, okay? Upon making the authority and purpose known, no? So, you can leave it with any of the officers of the homeowners association or condominium corporation. Magre-research tayo, no? Sino ba tong officers na to? Or it can be the chief security officer in charge of the community or of the building where the defendant may be found. Mas madali yon, no? At least do sa security guard, maitatanong mo yan, sino ba ang hepe ninyo dito kasi may kailangan akong ipa-receive. Okay? And then, of course, to make everything simple, go to letter D by sending an electronic mail, no, to the defendant's electronic mail address if allowed by the court. Ayun, ang importante communication, if allowed by the court. Now, nung dinideliberate po namin to, sabi namin, kaming judges, we were in agreement, let's not allow electronic service of summons, di ba? Kasi sabi namin, ito yung way to acquire jurisdiction. Kasi mahirap yun, hindi mo naman alam kung sino yung, although you sent it to his email address, pero hindi mo alam kung sino nag-open nun. No? Di ba? Hindi mo alam kung nakuha niya yon. Baka napunta sa spam folder niya or something. Hindi ko alam, di rin ako masyadong techie, no? So, but because it is very important for the acquisition of jurisdiction over the person of the defendant, kaming judges, we were against this. So, kaya ang ginawa naming compromise, ito, if allowed by the court. So, under special circumstances and with safeguards, pwedeng through electronic means. Okay? All right. Okay. So, and then on the next slide, you have a quote lang from jurisprudence regarding the requisites for a valid substituted service. But the next slide also, it speaks of action in personam or jurisdiction over the person is necessary, no, for the court to validly conduct proceedings and issue a judgment. That's for your own personal consumption. Okay, let's go to section 7, service upon entity without a juridical personality. Section 7, no change here except we, instead of using the word brought, no, that the action was brought, we said the action was filed. Okay, ano lang yan, stylistic. Section 8, service upon prisoners. Dinagdag lang po namin sa dulo, no, yung the jail warden shall file the return within 5 calendar days from service of summons, no? Kasi wala pong ganyan dun sa ating existing provision. And we want to emphasize the duty to file a return because we want to know, no, when we start counting the period, no? Okay? And then section 9, service consistent with international conventions, no? It is a reality that the Philippines has become a signatory to many international treaties and conventions, and they may have their own specific means for service or for the service, no, of court-bound papers. So ito po sinama lang namin dito to accommodate that, no? And then section 10, service upon minors and incompetents, no real change there, just stylistic and for clarification. And then section 11 is a new provision. Now, service upon spouses. Very, very clearly, we are saying if the spouses are sued jointly, you have to serve them individually. Okay? This is just an acknowledgement that the husband is the husband and the wife is the wife. Even if they are sued jointly, they are separate individuals. Even if they are supposed to have a community of interest, they still have individual rights. And that is why you must each serve them with a separate summons. Okay? Next, section 12, service upon domestic private juridical entity. Okay, let's go to section 12. Okay, ito yung mga domestic corporations natin. So, clarify natin dyan, no? Dinagdagan natin ng clarificatory phrases dyan. And kasi naging mahirap, no? Ang hirap hanapin ng president. Hindi ka naman magsaserve ka, kung process server ka, at sinabi mo, I want to see the president. Do you think papapasukin ka? Diba? Definitely hindi. Not even the GM or the ORSEC or the in-house counsel, no? So napakahirap. Kaya that just as a practical inclusion, nilagay namin in their absence or unavailability, their secretaries. Kasi it is a reality, no? Na sila naman ina-assist ng secretaries nila in everything. Yung secretaries nila ang magpapasok ng lahat ng papers na kailangan nila makita, no? So this is just an acknowledgement of that reality, no? And then so yun muna, no? So the designated officers, no? And then or the secretaries, okay? By the way, yung designated officers, wherever they may be found, hindi lang dun sa office, okay? So the provision now includes that phrase, wherever they may be found, in reference to serving the president, the general manager, the managing partner, the corporate secretary, etc., wherever they may be found. Kasi magtatago, nasa opisina, magtatago, or hindi ka paaakitin sa office nila, eh kung alam mo yung bahay, tas na-serve mo sa bahay, pwede, wherever they may be found, okay? But kung hindi mo sila talaga mahanap, sa secretaries nila, because they're the secretaries, nililimit natin to sa opisina kasi dapat official, okay? The official connection must be there, all right? And then, kung wala pa rin, kahit sa secretaries, then a person who customarily receives correspondence at the principal office of the defendant. Dinagdag din po natin to. Okay? Kasi pangkaraniwan, hindi ka na rin makakaakyat dun sa floor ng office ng president or ng GM, di ba? Eh, nandun din yung secretary nila sa floor na yun. So, hindi ka na makakarating doon. So, we acknowledge that reality and so we added this. A person who customarily receives correspondence at the principal office of the defendant. Okay. Now, despite all of these options, hindi ka pa rin makaserve, no? Or you are refused after 3 attempts on 2 different dates, no? On the next slide, you will see, Attorney Renz, the next slide, pwede na ang electronic service, but again, with a qualification, if it is allowed by the court. All right? Okay. Okay. And then on the next slide, you just have jurisprudence there, no? Regarding service. And the officers allowed to receive on behalf of the corporation. Now let's go to section 13. What is the duty of the counsel of record? This is important. This is new. And alam ko marami sa ating mga litigants baka ayaw to or i-question to, no? But we thought of adding this, no? Kasi first and foremost, di ba may hierarchy yung duties ng counsel? Before your duty to the client, you have a duty to the court. And above the duty to the court and to the client, you have a duty to society. As officers of the court, you have to help in the administration of justice. And that is why I know you will support the inclusion of this provision. Kasi po, dito sa provision na to, sinasabi namin, where the summons is improperly served. Okay? So talagang may admission, there was improper service of summons on your client. So now you make a special appearance on behalf of your client defendant, no, before the court. And you question the validity or the efficacy of the service of summons. Ang sabi po namin dito, now we can deputize you to serve summons on your client. Okay? And I think that is only fair. Okay? Kasi nandyan na kayo. What is the essence of serving summons on your client? We want to acquire jurisdiction, of course, but why do we want to do it this way? Because you have a right to participate. You have to have your day in court. Pero kung andyan ka na, sinasabi mo na sa amin, na-serve yung client ko pero mali yung pagka-serve sa kanya. No, it is an invalid way of serving him. Ibig sabihin, na-notify na kayo. You were given notice already. So why do we need to unduly delay it just for this technicality when you are already present before the court? No? So ito, ini-implore ko kayo, litigants, our lawyers, no, our practitioners, na to give this provision a chance because we are very, very sure it will cut a lot of externals or unnecessary interlocutory incidents before our trial courts. Okay? Next, Section 14, service upon foreign juridical entities. No? Ito, may distinction tayo dito, Section 14, Attorney Renz. Okay. If you're doing business, no, in the country, we know you serve through the resident agent or the designated government official or any officer, agent, director. Dinagdag po namin yung director or trustee in the Philippines. Okay. Now, if you are not registered or you have no resident agent in the Philippines, but you have transacted business in the Philippines, then service outside the Philippines is allowed, no? First, by personal service through the foreign court, the designated foreign court. Second, through publication in the foreign state, no? Plus, it must be accompanied by service at the last known address here. And then through facsimile, ina-allow po natin. Electronic means, ina-allow din po natin. And any other authorized means will be the last one. Okay? That's Section 14, foreign juridical entities. Let's go to Section 16, service upon defendant whose whereabouts are unknown. Okay. Okay, so ito po, finix na po natin. I discussed this earlier, no? But we just fixed the period here, 90 days, no? Para hindi po unduly lagging or stagnant sa ating docket itong mga kaso na to. Hindi natin mahanap ang mga defendants, no? So, anong gagawin natin, no? So, gaano katagal tayo dapat maghintay bago natin to i-archive or dapat ba natin to i-archive? Ito na po, inayos na po natin, no? So, the period at 90 days from the commencement of the action, okay? And also the period to answer in case it is published, all right? Extraterritorial service, let's go to section 17. Okay, so the only change here is to add the phrase as provided in international conventions, section 17, Attorney Renz, extraterritorial service. To add as provided in international conventions, no? Yun lang po yung nadagdag natin dyan. But the rule stays the same. But just for your own perusal, no, at your leisure, I have explanatory slides there which distinguishes an action in personam and an action in rem and quasi in rem, no? So para lang po sa guidance nyo kasi we know what section 17 applies to. All right? Okay, and then let's go to section 20 on the return, no? The officer's return. If you look at section 20, Attorney Renz, under the old provision, section 4 on the return, wala pong period when the sheriff or the process server, section 20, Attorney Renz, the slide on section 20, return, yes. So there is no period there when the officer is supposed to serve the summons, okay? Meron lang siyang period, 5 days when to file a return, no? 5 days from service. Pero hindi sinabi sa kanya kung kailan niya dapat i-serve yung summons pag na-issue na, no? So sabi ko nga sa inyo, the objective here is to put a time frame to every aspect of the litigation, no? Kaya ito, nilagyan na po ng time frame within 30 calendar days. From the issuance of the summons, the sheriff must serve it. Okay? So, yun. So, una, 5 days dapat mag-issue ng summons. So, dun sa 5 days na yun, nagkaroon ka na ng judicial determination. Is this dismissible outright? Is it sufficient in form and substance? No? So, if it is not dismissible outright, and if it is sufficient in form and substance, then you issue summons within 5 days. Okay? And then now, after the summons is issued, it will be handed over to the sheriff. The sheriff has 30 days to effect service, no, in the modes that we have discussed, okay? And then 5 days from the service, the sheriff must file his return. And we already stated, eto na po yung mga sasabihin niya sa return niya. Nakalista na po lahat dyan. We don't need to go through them one by one. You can do that at your own leisure, but as I've already mentioned them earlier, and we already have the template of the sheriff's return for you also. Okay, let's go to section 21, proof of service. Okay, so we discussed this already earlier, no? Section 21, please, proof of service. Yung nadagdag lang po dyan yung sa electronic mail, no? We just made it consistent. This is already the same provision that we encountered earlier on under Rule 13 on proof of service. And then Section 22, proof of service by publication, pinalitan lang po natin, Section 22, Attorney Renz, yung printer, his foreman or principal clerk to the publisher, no? Yung affidavit of publication, who will execute it. Section 22, I'm talking about Section 22. Now we're on Section 23, voluntary appearance. Ito, this is a significant change. Okay, dati po, you can appear to challenge the jurisdiction of the court over the person of the defendant. No? And if you invoke in your motion other grounds aside from lack of jurisdiction over the person of your client, you will not be deemed to have made a voluntary appearance. The new provision is the entire opposite. Okay, now if you invoke any other ground in your motion to dismiss, okay, aside from the lack of jurisdiction over the person of your client, then it will be deemed a voluntary appearance. And that is only logical, because if you invoke the jurisdiction of the court to seek relief other than for the lack of proper service on your client, then that is an acknowledgement of the jurisdiction of the court. Diba? So balik tayo dun sa old rule. Yun yung old rule before the 1997 revision. Okay, so the subsequent slide just shows you some jurisprudence on that. Okay, now let's move to Rule 15 on motions. It's 11:30 already. This is very long kasi. Okay, so Section 2, motions must be in writing. We have made, Attorney Renz, for on motions, Section 2 of Rule 15, no? Okay, so ito yan, ha? Significant changes then. Okay, so dati ang rule natin almost I am sorry. I'm sorry I lost all of you. Okay, I'll continue. Okay, so if it's made in open court in the course of trial or in the course of a hearing on any incident, then it must be resolved in the same session, no? So that means that the court must give an opportunity for the opposing party or the adverse party to make a comment also to that oral motion, and then the court will make an oral resolution. Of course, all of these will be captured in the transcript for that particular court session, and in the order, the resolution on the motion will be encapsulated also in the order of the court for that day. No? Now, the second type is a motion which based on the facts will require a summary hearing. No? So, kasi the facts do not appear on record. So, pag ganyan, the court itself will set it for hearing. No? And the court may require some submissions like affidavits or depositions to be presented. No? So that oral testimony may also be resorted to according to the provision. So, remember that, no? So, ngayon, yung motion mo may be made orally in the course of trial, in the course of a hearing, and then it will be resolved in the same session as much as possible. And then second, if based on facts which do not appear on record, the court may set it for hearing if necessary, no? Or kung hindi naman, the court may just require the submission of affidavits, depositions, or even oral testimony to resolve the motion, okay? All right, let's go to the next slide. Now we have two new sections, no? One is about non-litigious motions, and the succeeding one is about litigious motions. We thought of doing this, no? Para klaro na sa judges natin, ano ba yung mga motions na dapat nating iset for hearing? Ano ba yung motions na hindi na kailangan ng notice sa kabilang party, okay? So motions which the court may act upon without prejudicing the rights of the adverse parties, ito yung section 4 natin, motion for issuance of alias summons, to file an answer. But remember, it must be one extension only. So if it is a second motion for extension to file answer, that becomes litigious, no? Okay, and then a motion for postponement, motion for issuance of a writ of execution, writ of alias writ of execution, writ of possession, and then order directing the sheriff to execute the final certificate of sale and other similar motions. Basta ang ating all encompassing qualifier is without prejudicing the rights of the adverse parties. Okay, these motions will not be set for hearing. They will be resolved motu proprio by the court, and the period is 5 days. Okay, 5 days, ha? Judges, please take note of that, ha? You will resolve this motu proprio 5 days from receipt. Okay, next. Next slide. Well, it's just a description of what non-litigious motions are. And then section 5, let's go to this. These are the litigious motions, okay? So they include motion for bill of particulars, motion to dismiss, no? Only on the specific grounds allowed now. So the court may not act upon these motions ex parte because they will prejudice the rights of the adverse party. Let's go to the next slide, Attorney Renz. Okay. So, ito ang requirements ngayon for litigious motions. First requirement, of course, is service, no? So, what are the modes of service? Nandyan po, the same, no? Personal service, accredited courier, registered mail, electronic means. Okay, second, it is automatic. The adverse party, upon receipt, will count 5 days. The adverse party has to file an opposition. Unless you don't want to file an opposition, okay? But do not expect the court to issue an order to you directing you to file an opposition. Automatic na yan, ha? Pag naka-receive ka ng litigious motion from your adversary, you have 5 days to file an opposition, okay? No need for a court order, remember that, okay? And then third, the court will issue its resolution 15 days from receipt of the opposition or lapse of the period to file an opposition. So lahat yan automatic, ha? So one, the service of a litigious motion or the filing of a litigious motion in court and service on the adverse party will kick off this chain of events. Remember, wala na yan wala nang court orders yan. Automatic lahat yan. Okay? And then section 6. Now, this is the discretionary hearing I was talking about, no? There will be those motions, litigious motions, where the court may deem it necessary to hold the hearing, no? So pag ganyan, it will be the court which will issue the notice of hearing to the parties, no? And when you receive the notice of hearing, then that's when you set off that particular incident, no? Okay, in the proceedings. All right, let's go to the next slide. just a recap, notice of hearing is no longer required for litigious motions. The opposition is automatic. The resolution is also automatic, unless the court determines that the hearing is necessary, in which case the court will issue the notice of hearing itself. All right. Section 7, proof of service. Kailangan pa ba ng proof of service ng motion? Okay? Yes. So yung notice of hearing, hindi na ngayon kailangan, pero yung proof of service, laging kailangan because that's due process, no? That's a due process guarantee. Okay? So ano yung ating modes of service? The same. Personal, registered mail, courier, and electronic mail. All right? Facsimile. Okay? And then Section 8 is motion day. Fridays pa rin, motion day, when the court decides to hear a litigious motion. Friday, it doesn't say if it's morning or afternoon, just says Friday. And then Section 12, prohibited motions. Now we have this new provision where you have prohibited motions. No, these motions are not allowed. Okay. So motion to dismiss, we already discussed this, except for the limited grounds. No, yung number 3, bar by prior judgment, kasama yung bar by statute of limitation. So magkasama yung ating res judicata and prescription. So actually there are 4 grounds there. Okay. Letter B, motion to hear affirmative defenses. I told you, nire-resolve na yan ng court agad-agad, no? Unless the court deems it necessary to set a summary hearing where facts are still unclear, no? And then a motion for reconsideration of the court's action on the affirmative defense. Okay, bawal din ang Rule 65 dyan. And then a motion to suspend proceedings if there is no TRO or WPI from a higher court. Okay, bawal na yan. Okay, and then next slide, please. Motion for extension of time to file pleadings, affidavits, or other court submissions, except a motion to file an answer, but only once. No, we discussed that. And then this is important, motion for postponement intended for delay. Okay, so paano natin malalaman if it's intended for delay? Well, the presumption is that it is intended for delay, except if it is based on acts of God, on force majeure, or on the physical inability of the witness to appear and testify. Okay? So yun lang po ang ina-acknowledge natin na grounds for a motion for postponement. But the caveat is here, if a postponement is granted to you, you must still present your evidence within the remaining period of time allotted to you by the court. You will not be given additional time, right? And then the last paragraph just refers to the payment of the postponement fee. Your motion for postponement will not be acted upon until you pay our postponement fee. Okay. Section 13, dismissal with prejudice. What are the grounds? If the dismissal is based on res judicata, prescription, and then payment, waiver, or other grounds for extinction of the liability, or if it's unenforceable under the statute of frauds, then it is a dismissal with prejudice. All right? Okay, let's go to Rule 16. Actually, Rule 16 on motion to dismiss is no longer existent because its provisions have either been deleted or transposed, as we have already discussed. Now we go to Rule 17, the dismissal of actions. No changes here, no? Walang change dito. Okay, so they remain the same. Okay, all the provisions. So I just have for you some doctrines there. Okay, let's go to the next slide. Rule 18. Now we go to Rule 18. When we talk about pre-trial, we always have to consider AM 03-1-09 SC. This is a 2004 administrative matter during the time of then court administrator and now retired Supreme Court Justice Presbitero Velasco. This is the pre-trial guidelines. No? So kino-consider pa rin natin siya. Rule 18 is being interpreted in conjunction with that AM. No? Okay. So dito, when do you conduct it? 60 days from the filing of the last responsive pleading. That will be your answer or your reply, no? And dito, the important change is now the branch clerk shall issue, okay, within 5 calendar days, the notice of pre-trial, okay, from the filing of the last pleading. So binibigay na po natin yung duty doon sa branch clerk. Again, this is in line with our objective of putting time frames to every aspect of our litigation. Okay, let's go to the next slide. Nature and purpose. So we just made this consistent with the contents of our pleading. Now we have identification of witnesses and setting of trial dates, no? And then next slide. Okay, so next slide, meron tayo dyang ano. Ito very important, procedural. Ito na ang mangyayari, no? Pag pre-trial, So we have now in this section the requirements for the parties regarding the marking of evidence. We thought of including this. We fought to include this, kaming judges. Kasi ito po talaga nakakapagpatagal sa atin. Yung marking comparisons in open court. No? When I was a judge, ito po yung part that I hated the most. Because it's so tedious and boring and talagang nakakaantok po. So ito, we are taking it out. No? We are taking it out of trial formally and officially once for all. Ito na po ang gagawin natin. These are the steps. Now, one, mark your evidence if they were not marked in your judicial affidavit, although that is a requirement. No, but just in case you did not, then mark it dito. Okay. Then second, you make comparisons with the adverse party and or the BCC. Kung ayaw pumunta ng kalaban mo, kayo ng BCC, i-compare mo. Okay? Kasi ang inattach mo sa judicial affidavits mo, hindi originals, okay? Because you don't want to lose your originals naturally. Okay, you make the comparisons, okay? And then of course, you have stipulations regarding the faithfulness of the reproductions kasi ang binark mo photocopies, okay? And then also, you secure stipulations regarding the genuineness and due execution, okay? We don't want to have repeated challenges about the genuineness and due execution of documents in open court, all right? That's one of the purposes of pre-trial. And then fourth, you reserve evidence which is not yet available at that time. Ito na. So, lagi, pag pre-trial, there is a blanket reservation of such other evidence as may be necessary in the course of trial. Bawal po yun. Okay? No more reservations. No more blanket reservations, I should say. You can reserve, but you have to do it in the manner that we have established here. First, if it's testimonial evidence, you have to give us the name and the position of the person who's going to testify, plus the nature of the testimony. Now, we will understand you if you cannot provide a name. Just provide us with the position, okay, of the person whom you will call and the nature of the testimony. That would be okay. And then second, if it's documentary or object evidence, you have to give us a particular description, okay? Otherwise, we will not allow a reservation, okay? So yan po yung essence nitong ating introduction of these new provisions in this particular section, no? Now, towards the end, there, the failure. What is the effect of your non-appearance at pre-trial, no? So, with regard to the marking of evidence or the presentation of your evidence, what would be the effect? The effect is you waive all objections to first the faithfulness of the reproductions that are marked by your adversary and compared in front of the branch clerk. And then second, you waive any objections to genuineness and due execution of these same documents, all right? And if you fail to bring the evidence to the pretrial, for example, pretrial, and then the judge says, did you bring your evidence or the originals of the evidence attached to your affidavits, no, judicial affidavits? And you say, no, Your Honor, I was unable to bring them, no? What is the result? You waive the presentation of such evidence, okay? So we are being strict now, no? Kasi kung iisipin lang natin, let's just be very objective when we reflect on these new provisions, you will see that what we really want here is to cut out the delay. No, I don't want to use another word for it, but that's what it is. No, we want to throw away all the non-essentials. No, let's just focus on the real issues. Okay. All right. Let's go to the next slide. So I just have a quote for you about the nature of pretrial on the next slide as well. No, the nature and purpose. We know what it is. But there are still people out there who do not believe that pretrial is really, really a great tool for shortening trial. No? So kaya please make meaningful pretrial, conduct a meaningful pretrial. No? Let's go to section 3, notice of pretrial. We have a form. No? That's a good news. You just look at the form and you find it in the SC website together with this rule, no, with the rules, no, and we prepared that form for you. So sundin nyo lang po yun, no? But I just wanted to point out that now the form, the notice of the pretrial will include all parts of pretrial. So nandyan na po yung pretrial, nandyan po yung ating court annex mediation, nandyan din po yung JDR. No? Kasi naguguluhan ng mga tao sa atin. We send several notices. We send a notice of pretrial, we send a notice of CAM, we send a notice of JDR, nagugulo na po sila sa atin, no? So when we send the notice of pretrial, everything should be there already, okay? And then service, no? is important. No, we serve it to the counsel if a party has appeared by counsel. And it is the counsel's duty to serve his client or notify his client. Okay, that is just jurisprudence being institutionalized. Now, if the party does not have counsel, then we serve it to the party himself. Okay, and then we have a warning there that non-appearance will result in the necessary sanctions being imposed. Okay. And then, of course, here in the appearance of parties, the representative's authority is required to do three things: enter into an amicable settlement, to submit to ADR, alternative dispute resolution methods like CAM and JDR, and to enter into stipulations or admissions of facts and documents. No? Ano na po yun? That's also in long-time jurisprudence. No? And then let's go to failure to appear, Section 5, non-appearance. No? If you are duly notified and you do not have any justifiable or valid cause for your non-appearance, no, then you, when I say you, it has to be you, the client, and your counsel. Okay, if not just a client, so you will be penalized in this way. If you're the plaintiff, your complaint will be dismissed with prejudice. Okay, it's a dismissal with prejudice. And then second, if you're the defendant, the plaintiff will be allowed to present evidence ex parte. Okay? Unless, and here, the court will render judgment after the ex parte presentation on the basis of the evidence offered. Look at the clarification that we introduced there. You have to offer your evidence. Just because it's an ex parte presentation, we do not dispense with the requirement of an offer of evidence. Okay? So those are the effects. We all know the effects. They are just a carryover, okay? And then the pretrial brief, Section 6. Just to be consistent with the prior changes, we added those, no? The main and factual legal issues, no? Ayan. I remember, I think this was Judge Jolo who insisted that we include the main factual and legal issues. And then the next slide, no? The referral to commissioners, and then names of witnesses, and the brief statement of points of law and citation of authorities. Okay, effect of non-filing, still the same. No, it's as if you failed to appear at pretrial. All right. Now let's go to the pretrial order. Good news, again, to our judges, we have the form. We prepared the template. It's attached to the revised rules, which you find on the SC website. So you can just follow that as a template, okay? Of course, you can devise your own or prepare your own. Okay, that can be your guide, no? So eto lang po, these are the things that we need to see in your pretrial order. Okay, this is a new provision in the pretrial order, no? The direct testimony of witnesses for the plaintiff shall be in the form of judicial affidavits. Actually, hindi po new kasi they've been around since the Quezon City Practice Guidelines and then the judicial affidavit rule, no? And this has become the mode of examination in our courts, okay? But then the succeeding paragraph speaks of the no postponement rule except for acts of God, force majeure, or physical inability, which must be duly substantiated. Well, medical certificate, affidavit, whatever. Okay. And then, again, the same warning that if you postpone, no? That if you postpone the, or you ask for a postponement and are granted a postponement, then you will not be given an extension of your period for presenting your evidence. You will just have the balance or remainder of the period assigned to you. Okay. Now, what will happen if the defendant is absent during the presentation of evidence for the plaintiff? Then the defendant waives any objections to the testimony being adduced as well as any cross-examination. Okay, now let's go to Section 8 on court annex mediation. No, this is a new provision. We all know that court annex mediation actually precedes pre-trial proper, but here we reverse the steps, no? Mauuna po yung pre-trial proper natin because the thinking and this was the reasoning of our Chief Justice is that during pre-trial where the judge presides, maraming mas nako-convince to settle, no? And if it can be settled already there, why send it to mediation? Okay, so also to save on time, yun yung big rationale dito. So mauuna yung pre-trial proper, pero kung after nung pre-trial proper, meron pa ring hindi pa rin nagka-settle, no? That's when we send it to court annex mediation. Na-reverse lang po yung order, no? So, but here we also fix the period for CAM to 30 days maximum. Okay? And then Section 9 is JDR. Okay? Ngayon, ang JDR po natin, hindi na mandatory. It becomes discretionary. The judge will determine if there is still a possibility of settlement. No? After CAM fails, no? If there is a possibility of settlement, JDR will be set. But now the rule is the judge who is handling the case will refer it for JDR to another court. If JDR fails, the case will be returned to the original judge. Hindi po like before that the original judge will do the JDR. If it fails, it will be unloaded. No, that spawned a lot of problems, no, among judges. Kaya mas maganda na po itong rule na to. Now the original judge will just refer it for JDR to another judge, and then if JDR fails, back to the original judge. Anyway, the original know everything already kasi siya na yung handling judge from the start, especially siya na nag-conduct ng pre-trial. Okay? All right. And then let's
Justice, can we pause for a while? Is it okay? I am receiving so many requests for a second session.
Oh, okay.
Will that be okay?
Oo nga, kasi it's really long. I'm sorry, I do not want to skip any.
Not only that, Justice, we have about 70 questions already. 70 questions flash on the screen.
Okay.
So obviously there so much interest on your lecture. Can we do a second session, Justice?
No problem, Dean. When do you want it?
Whatever is your convenient time, Justice.
Sige po. Let's agree on a date later. Okay. Opo. Sige po.
So you can just continue with the slides until we end at what 12 o'clock or something, and then we set another session, Justice.
Dean, let's just end with pre-trial. So
great.
We'll start with Rule 19.
So I've been getting so many thank yous already for the second session, Justice.
Okay. Oo nga po, ang haba po kasi talaga nito.
Yes, we understand. Yes, we understand. But we're enjoying it a lot. Thank you.
Okay, sige po. I'll just finish the next slide, which is Section 10, and then we can end.
Okay, Justice. Yes, thank you.
Sige po. Okay. So we're finished with JDR, which I said is now discretionary. Let's go to the next slide, Attorney Renz, which is Section 10, Judgment After Pre-Trial. No? This is a new provision, and this is very, very important. A very, very useful tool for both the litigants and for the judges. No? Here, I'll read it to you. Should there be no more controverted facts, okay? Or no more genuine issue? Meaning, may issue ang parties, pero hindi na genuine. Kasi from what has been submitted before the court, kasi kompleto na yung evidence by that time, no? This is pre-trial. So no more genuine issue, maliwanag na sa judge, no? Or there is an absence of any issue, or should the answer fail to tender an issue, no? Then the court shall, okay, without prejudice to a party moving under Rule 34 or Rule 35, either for summary judgment or judgment on the pleadings, the court may motu proprio, no, include in the pretrial order that the case is being submitted for summary judgment under Rule 35 or judgment on the pleadings under Rule 34 without need of further memoranda or position papers. Okay? If that is the case, the judgment will be issued within 90 days, no, from the termination of pretrial. Now, you have to take note of the last sentence there. The order of the court to submit the case for judgment pursuant to this rule is not subject to appeal or certiorari, no? Kasi nga, ang objective natin, ayaw na natin yung mga interlocutory incidents that cause delay to us. All right, so this is new, this is important kasi in not a few cases, no, nangyayari talaga to, even when I was a trial judge. Dun pa lang, because you conduct exhaustive pretrial, nakita mo na no? And there is no need for presentation of evidence. Ito yun when there is no need for presentation of evidence, lalo na po ngayon, because all your evidence will already be attached to your pleadings. So I anticipate a lot of decisions on the basis of this provision. So I urge our judges to do their work and use this to their own benefit. No? So we'll end here as requested by the Dean. And we'll continue on a date that we will agree on and we will announce to all of you. Thank you very much for listening to us today.
Thank you very much, Justice Monet. Yes, Dean.
Probably we can collate the questions so we can send to Justice Monet.
Yes, sir. We have already
about 78 already. 78 questions already.
This is just on Zoom, Dean. We have other questions collected from the FB live streaming. So
Wow,
madami
wow,
tayong questions. So
wow.
there's really a lot of interest in this
Okay.
topic. So we definitely need a second session.
Okay.
We will just post the new schedule, the additional schedule through the FB page of the UST Faculty of Civil Law. So just watch out for the new schedule. As soon as we have that, we will post that immediately. And then for your other questions, those have already been, which questions that have been already posted in the Q&A as well as in the FB Live will all be forwarded to Justice Singh today para makita na niya. And then for other questions during the next session, pwede pa rin po tayong mag-post ng questions dun sa ating Q&A box and sa comment section ng FB live streaming. So with that, unless Dean or Justice Monet, you have a message for everybody before we break and wait for the next session?
Well, another brilliant lecture from Justice Monet. I think you have to have your good lunch now, Justice. You need to have your lunch. So at 12 o'clock. It's been very exhausting, I'm sure, to conduct a lecture for 2.5 hours.
Hindi naman po, alam nyo this is my passion Pag nagle-lecture ako, hindi ko namamalayan yung oras. Opo, thank you very much for this opportunity, Dean.
Thank you again, Justice. All right. See you again next time.
See you again.
We'll set the date. All right. Thank you.
Sige po,
Okay, thank you
salamat
very
po.
much, everyone.
Thank you,
And stay
Sir
safe.
Renz.
Oh, happy weekend po sa lahat. Magandang tanghali po.
Thank you.